Good. How's everybody? Okay. I'd like to welcome everybody to today's CLE, the 15-minute voir dire. Just a few announcements to make. The program will be recorded, so if you miss anything, you can get a copy of it. There will be 2 codes given, so pay attention. You'll have to record the 2 codes on the affirmation sheet to get credit. There's also an evaluation at the end. Please fill out the evaluation and get that back to the committee. The affirmations and evaluation should be submitted directly to Barbara@rocklandbar.org. There will be a question and answer period at the end, and John has graciously offered to make them case specific. So if you have a case coming up that you're working on and you have questions about what kind of people should I look for in voir dire, what kind of things should I do, John will be able to handle that. Raise your questions in the chat, and then I will read the question to John, and then he'll take it from there. We'll just set aside about 15 minutes, maybe 20 towards the end for that. We have upcoming CLEs. We're pretty much done now until the fall, because in the summer, nobody's going to pay attention. But we have the installation dinner tomorrow night. We have CLEs about in the summer about running a paperless office and opening statements. I think those are coming up shortly, right, Barbara? Is that true?
Yeah, they don't have exact dates yet, but
okay.
One may be in the fall. The summer.
most of the stuff gets pushed off to the fall. Maybe there'll be something in the summer if that we can get into that. In the fall, we're going to have a series on the surrogates court practice, substance use testing and parental alienation and gatekeeping, some family court matters. On the criminal law front, I am planning to do in the fall, hopefully if I get the time with all this trial schedule I have, to do challenging and controverting search warrants. Because every case we have nowadays, there seems to be like half a dozen search warrants. And so we're going to be hitting that topic, including cell phones and computer search warrants. Please mute your microphones so that you don't interrupt the speaker. And at this point, I'd like to introduce our speaker for today. It's John Ingrassia. He is a partner in the Newburgh law firm of Larkin, Ingrassia, LLP. He is currently exclusively practicing criminal law. He graduated with honors from Syracuse University College of Law in 1988, served as a clerkship with the Appellate Division 3rd Department, then went to the Orange County DA's office where he was a trial attorney from 89 to 93, and he's been in private practice since 1993. Started doing civil and criminal, now does exclusively criminal. He's handled many cases, homicides, a lot of DWI cases, rape cases. He's tried them all. And he's picked juries all over the place. So he's got a lot of experience doing that. He's lectured on various topics, including this topic, to various associations, including the New York State Association of Criminal Defense Lawyers, the New York State Bar Association, Orange County Bar Association, and the Dutchess County Bar Association. He's also extensively on DWI related issues. So at this point, I'd like to turn it over to you, John, and I'm going to turn off my mic for now.
Thank you very much. So I labeled today's topic the 15-minute voir dire, but I told Michael that I would need about an hour to do it. So talk about something that doesn't make much sense. But at least in Orange County, and I know in Dutchess County, the last few cases that I've tried, the judges have really over the last number of years curtailed your time limits in jury selection. And you're lucky if you can get 15 minutes. Sometimes if it's a homicide case, they might give you 20 to 25 minutes in round one, but then they slowly do it. So how, as a practitioner, do you deal with those time limitations? In my opinion, you have to really begin with the premise and really the realization there's no such thing as a perfect jury. I don't care who you are. You're never, in my opinion, at least in my experience, and those who I've tried cases with, have ever found a perfect jury. But what you want to do is you want to find the people who are going to be, hopefully, the most great, if you can get them to be the most sympathetic to your client's case, but if not, at least the most open-minded and understanding to the themes and theories of your case. And it all starts, jury selection, in my opinion, with getting the jury to understand really what the theory and, if you can,
Recording in progress.
as trial lawyers, we're used to actually doing all the talking. So it's really counterintuitive. What you have to do, again, just in my opinion, but these tactics have at least proven successful for me and in a lot of my cases, is to get the jury panel to talk. Because you can learn more about an individual and a group of individuals by listening to them, right? We're given 2 ears and 1 mouth. We sometimes should really listen twice as much as we speak. That's particularly true during jury selection. How do you get the panel to discuss their feelings about the case? The first thing you do is you discuss your feelings. You know, the last jury trial I did was last fall up here in Orange County. And honestly, the judge gave us 15 and 15 for the first round. And I think 15 and 15 second round, and third round, 10 and 10. The DA spoke for almost 6 minutes before she even asked a single question of the panel. And I find that to be a very, very common experience, which then really almost gives you the upper edge. And what I consider the 15-minute voir dire instead of jury selection, in a lot of respects, it's really jury deselection, right? Because we're trying to eliminate those individuals who likely have built-in implicit biases that they may not even be aware of when they walk into that courtroom. So how do we first begin that initial discussion? You know, don't thank them. Don't say, you know, thank you for taking time out of your busy schedule. We know how important your families are and your jobs are and this and that. Nonsense, in my opinion. If you want to reintroduce yourself, that's fine. Hey, as Judge Brown just told you, my name is John Ingrassia, and I represent. Walk right over to your client and put your hand on his or her shoulder. What I'd like to do is talk to you a little bit about this process and about the case. But before I do that, I really want to talk to you about some things that really trouble me about this case. All right, now you're opening up. You're opening up, and this goes back to, you know, my 3 theories of trial practice and jury selection and jury trials. You have to be confident, you have to be credible, and then if you can be, you have to be somehow a little bit entertaining. But that doesn't mean you necessarily have to use humor. If you're a humorous person and you can sort of inject a little bit of humor in there, it's worked for me in the past. But that second prong, confident and credible, you're now opening up your own credibility, because while you're talking about your own feelings and your own vulnerability, you're being honest with them about what concerns you as you enter into this process of jury trial. So, how might that begin? Last case I tried was a child sex abuse case. And we did not, meaning the defense, did not have any explanation as to why this child would have falsely accused the defendant, who happened to be her first cousin. Now, if you have a case where you have a robust motive to fabricate, and I've tried plenty of those, that kind of leaves the door a little bit open. But I find a lot of sex abuse and rape cases go to trial because assuming there's no DNA forensics, no confession, no controlled call where there are admissions made, because people don't want to, well, one, they might very well be innocent, right? We assume everybody and presume everybody is innocent. But those are cases, in my experience, that go to trial a lot because of the attendant collateral consequences, being a registered sex offender, subjected to SOAR for at least the next 20 years. In those cases, I just go right out and say, I've got to tell you something. I'm concerned because I'm concerned, ladies and gentlemen, that you're going to ask me and really ask my client, David, why this child, this 11-year-old child, would be making up such a serious, serious allegation. Can anybody imagine being accused of such a terrible thing, a child sex abuse? And I know it's going to be something you want to believe. You understand coming in that people naturally want to believe any witness, particularly a child witness. But that's not how it works in the criminal justice system. And then you segue in, bridge in, use that as a lead in to the presumption of innocence. And again, I don't know how many lawyers here today will be able to argue all these things, because sometimes judges get a little bit particular about you commenting on burden of proof, presumption of innocence. That's why I would really strongly suggest before you begin any trial to print out the criminal jury instructions in New York State and read and understand. I know they're basic, but read. And if you use the same language, in my experience, at least, the judges are not going to give you an issue regarding you commenting on the law. And you do it in a way such as this. As Judge Brown or Judge Kim already told you, there's a presumption of innocence. And what that means is that everybody who walks in this courtroom, whether it was you, myself, the judge, the court clerk, or my client David, are presumed innocent. And an example I like to give is, if I were to ask you to deliver a verdict right now, or if the judge were to ask you to deliver a verdict right now, what would your verdict be? And you'll get varying answers, right? Somebody might say, well, I haven't heard any evidence. I couldn't give a verdict. And that's a wonderful, wonderful opportunity to seize. And sometimes you even had the judge kind of like steal the thunder a little bit and interject at that point and say, well, Mr. Smith, I already told you the burden of proof rests upon the prosecution, and it's only if they've proven beyond a reasonable doubt each and every element of the crime charged and the defendant's commission thereof that you can find them guilty. So if you haven't heard any evidence, what would your verdict be? Right? Verdict being not guilty. And then you go down the line. And if you get somebody to answer that question outright, it rarely happens, but sometimes it does, join in with a fellow juror. Do you, Miss Johnson, have a different answer than what Mr. Smith just gave you? Do you agree with that? Why do you agree with that? Why don't you agree with that? And what you're doing here, you're doing what I consider building alliances. What's an alliance, right? An alliance is a number or a group of individuals that form something in common, right? NATO is an alliance. Countries have alliances. Well, jurors can have alliances. Next time you're on trial, take note of something. And it almost always, particularly if the trial goes on for, at least a week, you will start seeing jurors walking out together, sometimes going to lunch together, oftentimes going to lunch together in groups of 2 or 3, sometimes even 4. Those are certain alliances. Now, I'm not saying they're deliberating. I'm not saying they're all going to vote the same way, but they do become friends. The goal in jury selection, also, one of the goals, is to build positive alliances and to break up, destroy negative alliances. What's a negative alliance? Well, a negative alliance is simply people who would say, Mr. Ingrassia, I understand what you're saying about the presumption of innocence, but I got to tell you, if a child says that they were sexually abused, I don't see any reason why a child would make something like that up, right? Now, you know that person is gone, right? That's a cause challenge, although, Mike Bonjero and I were just talking about the other day. I think a lot of judges nowadays, I don't know if they're taught this by OCA or whatever, they try like at great length, like pulling teeth to try to rehabilitate prospective jurors, even though they still have a panel of 75 people in the courtroom that can fill that person's spot. So you have to make a record. Jury selection also is about record preservation, preserving your challenges, making objections to courts who do not grant you cause challenges. And like I say, record preservation is so important in preserving every single possible appellate right in the event that there's a conviction. So in that case, all right, you just have identified a negative person. So you're going to ask, I understand that. I have 2 daughters of my own and a granddaughter. I really can understand where you're coming from. In fact, my wife feels the same way. And that's the truth, okay? My daughter feels the same way. That is the truth. Does anybody else feel the same way? And if you have 1, 2, 3, 4 people, get them to identify, put it on the record, Miss such and such, Mr. such and such, you feel the same way. Don't get them to share their feelings, because you're really kind of just now potentially going to be contaminating the remainder of the panel. But you now have identified 3, 4 individuals for cause. You're breaking up a negative alliance. And then what do? You flip it. And what do I mean by that? You use a generalized statement such as, we know everybody has difficulties when we're dealing with children. It's natural that we want to believe what anybody says, but particularly a child. Does anybody have an opinion different than what Mrs. Johnson just shared with us? And thank you, Mrs. Johnson, for your candor. I really appreciate that. And I know everybody in this courtroom does. And you will start to get people to take a different approach. And they say, well, I don't agree with that. Mr. Bonjero, could you tell us why you don't agree with what Mrs. Johnson just said? Let him state his reasons, give him a little bit of opportunity, then go on. Does anybody agree with what Mr. Bonjero just said? Show of hands. You know what you're doing now? You're building positive alliances. And again, going back to the situation of what we're all here for, to protect the constitutional safeguards of the presumption of innocence and the burden of proof. Give examples of how the presumption of innocence work. I just gave you one example, right? What would your verdict be right now? And if the judge gives you feedback, I mean, don't contaminate the jury panel. Say, Judge, may I approach me? I'm just asking it. Are you asking, am I to understand your Honor's ruling, not allowing me to do that, to say that if a verdict were to be called upon right now, my client would be guilty? You're not saying that, because that's not what the law is in New York State or any other state in the United States, right? And usually if you do it politely, they'll step back and let you go that route. Another great example that I've used is the perp walk, right? We've all seen the perp walk on TV, right? Publicized case, detectives in New York City or state police up here take out the subject in handcuffs. Cameras, TV crew there. Mr. Mahoney, what do you have to say? Did you do this? Did you kill Jessica? Did you kill your wife? The perp walk. What's your first reaction when you see that person being brought out in handcuffs in front of the police precinct in New York City or the state police barracks in Haverstraw or Middletown, New York? And get them, don't tell them, get them to say it. And most of the time, our prospective jurors are going to say, oh, they caught the guy. They got the guy who did it. Well, isn't that really prejudging a case? And you're actually not presuming somebody is innocent. you're presuming that somebody is guilty, which is the actual opposite of what the standard of proof is, and the burden of proof and the presumption of innocence. I sometimes go say, you heard the judge read the indictment. Okay, can you just share with me, Mr. Ryan, what your first thoughts were when you heard that? Disgusting. I have 2 children, and don't confront things, like hit force with force. Embrace it. Embrace it and say, okay, well, has anybody here ever heard of a situation online, read it online, saw it on TV about an innocent person spending decades in prison, only later to be completely exonerated and let out of jail by newly discovered evidence? Unless they're living in a rock or under a rock, everybody's going to raise their hand, right? So what do? Well, you talk about that. So then we can agree with the premise that innocent people can be wrongfully convicted of crimes, right? Because we know they're later exonerated through forensic DNA, witnesses who appear, later, and irrefutable evidence that's uncontrovertible. So what do? You're doing 2 things, right? You're showing them how this presumption of innocence and the burden of proof is not infallible, because innocent people, and you can't think of as terrible as a child being sexually abused is, we can agree that an innocent person spending years or decades in prison for a crime he or she never committed is just beyond terrible, whatever adjective you can think of. So talk about that, get them to express that. And isn't that really why the presumption of innocence exists? Because we don't want to have innocent people wrongly convicted. Isn't that why the burden of proof is so high in a criminal case? Because we don't want to have innocent people wrongly convicted of crimes they didn't commit. And again, this is not like a one size fits all. You have to, I'm just giving you theories, ideas that have worked for me, and hopefully they'll work for you. But in an identification or a he said, she said case, you're not going to necessarily be using the same techniques you are on a case where somebody's accused of possessing a handgun, a loaded firearm, or in a driving while intoxicated case, or in a case of an assault or a homicide where your defense is justification, self-defense. But you can pick and choose which techniques are going to be best for you, and hopefully they'll come into play. Remember, frame the questions in open-ended fashion as opposed to closed-ended fashion. If the BA fails to prove my client guilty beyond a reasonable doubt, your verdict will be not guilty. Don't ask that question, right? Of course they're going to say my verdict is going to be not guilty. Just like 10 minutes before, the prosecutor asked them, if I prove all of the elements of the crimes charged and the defense commission thereof, you will find my client guilty, or what will your verdict be? You have to go and think outside the box. You have to educate the panel of the theory of your case and identify the prospective jurors. So let's talk about educating about the theory of the case. All right. I like to use true or false questions because I think they save time when you have a very, very limited voir dire. The advantages of using those questions is that it's fast. It requires an individual to commit one side or the other. All right. It's either true, they agree with it, or it's false, they disagree with it. And it's a specific statement that relates to the theory of your case. So here's some examples, right? Discuss what you may think of the standard of reasonable doubt, and that how a reasonable doubt does not have to be the same reasonable doubt that juror 1 holds as juror number 3. I didn't say that very well. Get the jury to understand that a reasonable doubt can be individual to that specific juror, right? So you may have a reasonable doubt because you found that the person was off on the complaining witness on the times that she alleged she was abused. Whereas another juror, one says that, juror number 7 says, well, no, I have a reasonable doubt as to whole setup, how this could have taken place, as sexual abuse in a house with bedrooms upstairs, with the doors open next door. Get them to understand that the reasonable doubts can differ, but it's still a reasonable doubt, and they can discuss that amongst themselves. Because remember, any reasonable doubt held by a juror equals what? A verdict of not guilty. There are other ways that you can get the panel to commit to holding the prosecution to their burden of proof, right? And one way is, again, by kind of empowering them to be the guardians of the gate and the guardians of the verdict. If the goal is to really avoid wrongful convictions, you're empowering them to do something that they've already told you it is beyond a travesty of justice, of convicting an innocent person. And what it really is doing psychologically, in my opinion, it's elevating the burden of proof that the prosecutor has to something even higher than, beyond a reasonable doubt. Let's talk a little bit about your client not testifying, right? I go right out and lay it all out. All right. Does anybody believe that if my client David doesn't testify, he must be guilty? You don't get people to raise their hands, right? And I'm probably preaching to the choir here, because all of you have probably seen this at some point in time in your careers. And usually it's a man or a woman that says, well, listen, if I didn't do anything, I wouldn't have anything to hide. I'd want to get on that witness stand and tell my side of the story. Okay. So again, take it, don't confront it head on, embrace it, and then flip it. And ask them, the jurors, to give you some examples as to why an innocent person would not testify. If this were more interactive, we could show you an example of that right now, because I'm sure amongst everybody, I don't know how many attendees we have, we could probably come up with close to a dozen reasons why somebody might not testify. All you need to do is give them a handful. Let them, if at all possible, come up with the suggestions. Why? Because in doing so, you are letting them individualize their feelings. You're developing the theme of your case, particularly where your client is not going to testify. And also, you're identifying and building what we speak of, those positive alliances. All right. So like one example of why a defendant may not answer a question is because, I'm saying why a defendant may not testify is because the prosecution hasn't sustain their burden of proof. Another reason might be, the accused is nervous and is not professional speaker. And, another one might be on advice of counsel. Another one might be, I think we already said that. There's just no need given the lack of evidence, or maybe he made a statement to the police that was not inculpatory, but was exculpatory. Usually prosecutors don't introduce those, but I've been involved in some cases where they have. He told you what happened. He told Investigator Smith what happened. There's no reason for him to do that, but let the jurors try to do that. One thing, particularly in these child abuse cases, and then you can use these in other cases, is get them to concede. And this is in the written materials as well as you have, but I found the framing of these questions can be very, very effective. How many of you, by show of hands, have children? They do that. Are children capable of reciting a story to you that's not true? Oh, believe me. How many of you has that happened to? I mean, it'll look like the wave, like the sporting events, the hands will just start going up, and the more 2 or 3 that go up, it'll be 7, 8, or 9 before that. You then ask on one of the jurors, would you be willing to share with us the circumstances in which your child, it could be about a homework assignment, it could be about eating something that they weren't supposed to eat, breaking a window, not taking out the trash, not doing a chore, whatever the case may be, get them to do that. Then along, talk to the other jurors. Have you had the same experience as Miss Nichols? Have you? What was your circumstances? And always, especially when it's a difficult thing, just thank the juror just for sharing that information with them. And again, this goes same for adults. Can an adult make something up? Say something that's true. What might be reasons why people say things that aren't true? Okay. Suggest if they don't have, but usually the jurors, again, it's all condensed. If they're not, if you're running out of time, can a child make something up in order to get attention? Jurors start shaking their head. Identify which ones. Do you agree with Mr. Fitzpatrick? Can a child make something up in order to avoid getting into trouble or to get out of trouble? Can somebody make something up in order to please other people? Can a child make something up to receive some sort of sympathy from a parent, a teacher, educator? Can they make something up to transfer blame if they were caught doing something wrong? And then get them to try to talk about that, again, assuming that you have time. And again, after going through all of this, weave back in that burden of proof and presumption of innocence. That will you assure my client, David, that neither he or I will be required to prove to you why these allegations are false? Because it's human nature to want to have an answer, all of us, as to why untruthful allegations are going to be lodged against anybody, but in this case against my client David. But it's at that very moment that the burden doesn't shift. And if you have that belief that the story just isn't truthful, that's a reasonable doubt. Now you got to be careful. Some judges will actually cut you off, so you got to kind of have to see, how far the judge is going to take you. Again, we spoke about true or false questions. Here's an example. Show of hands. Someone charged with this type of allegation. You can use this on anything. Doesn't matter whether it's a DWI, a homicide case, a child abuse case, a weapons case, a drug possession case, a drug sale case. how many people think that anybody who's charged with this type of crime, the allegation must be true and therefore the client must be guilty? How many think it's true? How many think it's false? Why do you think it's true? Why do you think it's false? Again, building your alliances. True or false? Most people who are innocent never go to trial. True or false? My client better have a pretty good explanation for all of this. Why do we ask that question, right? One, we want to identify who individuals who are not going to adhere to the burden of proof and require us to shift the burden to us to explain why something isn't true. My client, David, is more likely to be guilty in this case than any other type of case. If we don't convince you why David could not have done what he's accused of doing, we have to convict. And again, you don't use all of these questions, but you can take a sampling. Really important, if the judge gives you any type of interference, there's some good cases from the US Supreme Court and also for the Second Circuit, and they're in your materials. Again, the standard is you can argue a challenge for cause because it can be inferred from a prospective juror that the answers to your questions renders that juror incapable or unwilling to decide the case solely on the evidence before him. And that's Torres case, Second Circuit, and cites in your materials. If you need anything, you can just reach out to me. Also, always remember that the Constitution confers the absolute guarantee to an impartial jury, which requires adequate voir dire, so the accused can be afforded an ample opportunity to identify and challenge unqualified and prospective jurors. And that's the Morgan v. Illinois case, 504 U.S. 719, 1992, from Scout, Supreme Court of the United States. So if the judge is interjecting his or her own objection, ask to approach the bench and start reciting. Judge, what I'm just trying to do is I'm trying to do an adequate voir dire so that I can identify, be afforded the opportunity to identify. That's very strong language. It's not saying you are identifying. You have to be afforded the opportunity to identify. And by judge, respectfully, if you're not allowing me to ask these questions, my client is really being denied that opportunity to identify and challenge, to make an adequate record as to why we're challenging that individual. Let's talk about, Mike, how are we doing on time?
John, we're at 12:40.
Okay, so we're doing pretty good, right?
Yes.
All right.
I'm gonna interrupt you right now
Sure.
to do the first code. Okay, so everybody listen. The first code is time. T-I-M-E. The code is time. T-I-M-E. Okay, all yours.
Okay, thanks. Let's talk about credibility of witnesses. I don't care what kind of case it is. If you're defending any type of case, a criminal case or a civil case, or prosecuting that for that matter, your jury is going to have to pass on credibility of witnesses, right? Trials are contests, they're really more than that. And, credibility, again, goes back to, in my opinion, establishing the theme and theory of your case. Every client has a story, and you have to convey your client's story to that fact finder. And one way to do it is, what's more believable? What are we saying when we're saying what's more believable? Really saying what's more credible, right? So, suggested areas of dealing with credibility. How many of you, show of hands, have ever had to decide a dispute between two people and determine who is telling the truth? It may be at home with your children. It might have been, with your best friends, talking about an experience that happened when you were childhood friends or in high school or college, roommates, might be from a situation at work. All right. Can you share with us the circumstances of those? And again, these are all going to be defined within your time constraints. How did you, Mr. Fitzpatrick, determine who was telling the truth? Can you share that with us? What factors were important to you in making determination? And again, these have to fit in with the theory and the theme of your case. Can we agree, these are great with prior inconsistent statements, if you have a lot of them, what a person has said in the past compared to what they're saying at the present is a relevant factor in determining the reliability of their story, right? Why is a person who is consistent in the story an important factor to you, Mr. D'Angelo, in determining the reliability of their story? Who agrees with Mr. D'Angelo? Oh, Miss Golding, thank you. Okay. Does anybody disagree with what they're saying? Very rarely you don't. And again, you're building again to your theory and those alliances. Has everyone ever been told something that they later learned not to be true? What led you to conclude that, right? Again, you're not giving examples. You're just making a statement and asking them. A lot of times when you ask that, you know, like they learn something and then later they learn it not to be true. Many times, I think the prospective jurors will give examples that the facts changed from the time they heard the story the first time to the time they heard the story a second or a third time. And why is that important? How can facts change, right? New facts can be added. Old facts can be left out. It's what? That test of consistency. And when you go back and read the jury instructions from the criminal jury instructions, one of the tests of credibility of witnesses is the test of consistency that they'll be hearing from the judge themselves. So if you say something in jury selection and in opening statements, but particularly in summations, this is not about a trial practice on summations, but if you say something and it's taken out of the CJI and then a half hour, an hour, 2 hours later, they hear the judge saying the same thing and using the same terms you do, what does that do? The second rule again, confidence, credibility, it makes you more credible. And the more credible you are, the more what? Believable you are. The more that the jury is going to want to or be inclined to accept your arguments. Now, reasonable doubt, always talk about that again. I can't emphasize enough, read the New York State criminal jury instructions. There's really good language in here that, again, you'll build in to whatever the theory or the theme of your case is. It might be, you know, good enough for government work, but not good enough. If it's a police case or government case and they don't do things that they really should be doing, testing the evidence, getting DNA, fingerprints, whatever the case may be. Because remember, reasonable doubt can come from the evidence itself, the lack of convincing evidence, inconsistencies, unanswered questions that you have regarding the nature and quality of the evidence. And that is really, I think, the way to harp on that high burden of proof, having been going in through, the other examples that we've already given. We've already spoke about client not testifying. All right, police officer as witnesses. All right, I would say the vast majority of our cases do involve some type of police officer testifying. Now, look, not all of them are going to be dispositive witnesses on what happened. DWI cases, they're the show for the DA, but you do actually have to explain to them just as the judge will, and really not explain, but really identify these pre-existing biases. By show of hands, how many of you believe a police officer is more believable than non-police officers? Again, you'll get people who testify. A lot of times it might be a spouse of a police officer, a good friend of a police officer, sibling, child of a police officer. Yeah, my dad was a police officer, and I knew a lot of his friends, and yeah, anything a police officer says, I tend not to be true. Can a police officer opinion be wrong or mistaken? And you can use this also with a witness. It's really, really difficult to want to say that a witness is lying unless you really, really have concrete, irrefutable proof of a lie. They can be mistaken, right? Lying or mistaken doesn't matter. It still equals what? It still equals a reasonable doubt or lack of credibility, which is your path to reasonable doubt. The great example that works, well with me, particularly in DWI cases, is, has anyone ever experienced they received a speeding ticket, okay, where you felt that the police officer who accused you was incorrect in his or her opinion that you were speeding? You will get hands in the panel. So in that situation, did you fight the ticket? You go to court. Why did you fight the ticket? Well, because I didn't do what the officer said I did. I said, I'm sorry, I didn't hear that, right? Get them to repeat that. I didn't do what the police officer said I had done. Has anybody else had a similar experience? All right. So the police officer was wrong, right? Now, police officer may have just made a mistake. Police officer may have mistaken your car with the car to the side of yours or in front of yours when he locked on with his dual stalker radar, right? Yeah, giving them an out. And again, that can be very, very useful in DWI cases, right? Because you don't have to, always remember, reasonable doubt doesn't mean somebody's lying. Could mean somebody is mistaken. It just means at the end of the day, okay, we just don't know what happened. We have questions that we haven't had satisfactorily answered. And what are those? Those are actual, not imaginary, but real doubts. Again, go back to your CJI, you're going to see those terms. Actual, not imaginary, right? So, I think we're kind of moving way ahead of schedule. It's almost 1 o'clock. And I think one of the more important things, again, to talk about is that empowerment of the jury to acquit. Juries will more often want to do something they find more pleasant than unpleasant. And if they do believe that there's unreliable evidence, and if you've already teed it up for them about wrongful convictions and innocent people being incarcerated for decades, you're now empowering them, giving them the keys to the kingdom to do what? To hold that prosecution to that ever high standard, and maybe psychologically even a little bit higher than what the law says, in order to make sure that they are not part of that travesty and sending an innocent person to jail and restraining his liberty for how many years. And again, you can talk about the 3 C's: confidence, credibility, and a little bit of entertainment. So we all agree people in our society have been, unfortunately, wrongfully convicted, only later be exonerated by scientific, irrefutable evidence, right? What are some reasons, and start to ask them why somebody can be wrongfully convicted of a crime that they didn't commit, right? you can suggest, pitch out a few ideas. The evidence might have been unreliable, but the jury just weighed it in a fashion contrary to your client's case. Could be false evidence, misunderstanding the law. Maybe the person had a bad lawyer. You'll get a few jokes, point to yourself. Hopefully that's not the case here. But again, you're getting them to understand that these two things happen. The presumption of innocence. What I always like to do somewhere in these he said, she said cases is, has anyone ever been accused of doing something they didn't do? Did people believe you on your word that you didn't do what this person accused you of doing? Were you able to prove you didn't do it? How were you able to prove you didn't do it? And again, marrying those thoughts with the fact that you have no burden of proof here. What are you doing? You're kind of teeing it up again, building those positive alliances, removing the negative alliances. And I think, for lack of a better term, just psychologically raising that burden of proof maybe a little bit so that you've empowered that jury to know they really need to get it right because they don't want to be part of the show that gets an innocent person wrongfully convicted. Now, look, this was just a smorgasbord. We can talk about more specific examples. It's a little bit before 1 o'clock now. I'm a member on the faculty of the New York State Association of Criminal Defense Lawyers, and we do a lot of these virtual CLEs. And what we find sometimes, at least I do, very helpful is when we kind of, take, 20 minutes, a half hour, whatever, to kind of have almost like brainstorming, almost like bring your case. It could be fact specific, or you can just ask questions about examples. It could be about past cases. We sometimes learn more from our losses than we do from our successes. But that's really most of the material that I've had. We've been going now for a little over 50 minutes. I can get a little bit more specific and into it, Michael, if you think, or really kind of open it up to let people how many people are on the program, attendees?
About 30.
30. All right, we've got 30 intelligent people here. We must have some questions, right? Does that sound like a good idea, Micah? And anybody?
Yeah, let's open it up for questions. If people can write them in the chat, and I'll convey them to John. John, what about while we're waiting for the questions to come in? I have a question.
Sure.
What if the judge keeps on cutting you off? You're trying to go into the burden of proof. You're trying to go into these areas, and he keeps on not letting you do it. What do you switch to?
Yeah. So, you be polite. I kind of sometimes relish the underdog because I think jurors will see if the judge is trying to interject and almost become an obstructionist. So again, I would politely ask to approach the bench and go back to the constitutional arguments, citing the cases, Torres and Morgan v. Illinois, that judge, I'm merely trying to adequately voir dire so that my client is being afforded the opportunity, just the mere opportunity to identify and challenge. And me speaking about the burden of proof and their willingness, I'm not misstating the law. And if I'm misstating the law, I apologize, and I know you will correct me. But you see, it's a great question, Michael, because judges very well may say, well, I've already instructed them on the burden of law, on the law, on the burden of proof and the presumption of innocence. And again, well, okay, so that means I can't then question. They've already agreed that they would follow that. But that's not enough. I get the right to question. I'm not bound by a witness's statement on direct examination because the prosecutor already asked that question. I'm trying to identify, and I have to be given the opportunity to identify and challenge unqualified. Listen, if they say, no, I'll follow the burden of proof. I'm just getting into, I have not had a judge cut me off on those types of questions that I've proposed in my materials. But you have to make it in a way that it's a constitutional argument and that you're not just asking the same questions. Okay, you instruct on the law, I'm just asking them of certain examples, and why the law exists may not be relevant to you, but it is relevant to me in identifying and getting the opportunities. I think that's the key, the opportunity to identify an unqualified prospective juror.
Another question, John, is that you've done a lot of DWI cases. Is there any particular questions with a DWI jury? How do we get them to feel some sort of identification with or sympathy for our client? Let's say it's a case with a close reading, no accident, you're going to trial. What's the ways that you use the voir dire to help your
Sure.
case on a DWI?
Right. So, you know, you've got to know what the proof is, right? Is it such a high reading, but the field test is really good? And it's what we commonly refer to as the disconnect defense, right? The test has to be wrong because, and nowadays with the videotape, say the old, was it Warner Wolf? Let's go to the videotape. You know, if it shows good common law evidence that he or she are doing well on the sobriety test, you talk about how you can connect in that situation to disconnect, for example. If it's a close case, but again, read the standard of proof of intoxicated, right? Under People v. Cruz and the CJI. It's a pretty high standard, but where you're vulnerable, and I've had plenty of cases where my client's been acquitted on the common law, but convicted on the per se. So on the per se, you got to be able to voir dire about, you know, devices and reliability and tests. You know, one way to do it is, you know, anybody ever here have a medical issue and themselves or a loved one, and it was a test, could be a blood test, could be another diagnostic test, but the doctors wanted to make certain, and they ran a second test because they wanted to be sure with the margin of error or whatever that the first test was not a false negative, false positive. Guaranteed you're going to get people to do that. Why do you think the doctor might want to do that, right? Well, they want to do that because they want to have as much, very few things in life are 100% certain, right? But they want to have as much assurance that the result that they got the first time was reliable. And then go through on a breath test, for example. You guys know, guys, ladies and gentlemen, know how many tests the pre-testing sequence of a Draeger or the data master, breath verifier is. You know, they do a pre-test, right? Then they do another test. Then they do the subject sample. They do another test, you know, on the simulator runs. Beginning, one before, breath test. Like there's 3 tests, sometimes 4 tests sandwiched in between, your client sample sandwiched in between. The point that I'm getting at here, it's only one breath test, right? And look at the New York State Department of Health rules and regulations, the law only requires one breath test. But if you can get the officer, the BTO, breath test operator, to concede the reason why they're doing multiple tests or what, to ensure it's reliable. Because if one of those tests was outside the standard, plus or minus, right, the degree of variation, you would have to abort that test, start the waiting process over, and do it again. I know the Department of Health, Trooper Bongiorno, only requires 1 test, but you did 3 tests on this. Again, so what's your theme of the case going to be? The lack of reliability of testing, the non-compliance with the rules and regulations. So whatever your theory and theme of your case are, that's what you voir dire on, particularly you know, in a tight, shortened voir dire. If it looks like the test is not reliable because the physical evidence and the videotape shows the person was not intoxicated or impaired, That's what you're voir diring on. So here's a perfect example. This is a true story. Had a DWI case, and client had a very, very bad record. So it was a felony reduced to a DWI. Then we tried it, got an acquittal, but it was refusal. And then we go to the refusal hearing. And the body cam footage was very, very favorable. It was an acquittal, but it should have been an acquittal, okay? But you truly never know what a judge or a jury is going to do. And in that moment, we go to the refusal hearing, which had been delayed. This is back in the old days where, they would let you kind of really put them out until after the criminal case was resolved. What happens? The the police officer testifies. This is way before computers and laptops and everything. We bring in the old, VHS player with a little TV, and we plopped in the tape for the ALJ. Judge Doynow, you guys remember Herb Doynow from Rockland County, and he was our ALJ up in Orange County. And he looks at the videotape, and after I'm done with my cross, he says to the cop, officer, I listened to your direct. I heard Mr. Ingrassia's cross. I've now seen the videotape Mr. Ingrassia introduced. Do you want to change your testimony? Does I don't understand? He goes, yeah. Do you want to change your testimony? I don't understand. What I'm seeing on the tape is not what you testified to. Clearly, your testimony is inconsistent with what's on the tape. And he says, no, I'm sticking with my testimony. Okay. I said to my client, I don't think you need to testify. I want to testify. So my client testifies. We take him through everything. And then what happens? The cop gets to question my client. And the cop is all on, you don't have the same perspective. This is a videotape. I was there. I was in person. I was live. I was seeing it, how it happened. And as a result, I was in a better position than to see it. Don't you agree it's better to see something live or on tape? He asked my client this question. I hadn't prepped him for this. He gave the best answer of any witness that I've ever heard in any proceeding in my 34 years of practicing law. He said, no, I don't agree with that. The cop was not wise, and he asked him, well, why? He says, are you a football fan, officer? He says, oh, yes. He says, well, there are trained professional officials, referees that are seeing things happen in real time. And, there's something called instant replay. You've heard that now, right? Where things are being recorded, and then the referee goes under the hood and watches things. And so he made a fool of himself, of the officer, because he said, videotape is better than live testimony. Again, if it's videotape that's helpful to you, to your client, then you rely on it. If it's not, those are typically the cases you resolve short of a trial. But I hope that answers your question, Michael. I mean, DWI is so intricate. You could have a blood test, you could have a breath test, you could have a refusal, the field sobriety test, operation issue. So the voir dire there is really, really going to be fact specific, but I would always include the credibility of witnesses. And just because you find that there's not proof beyond a reasonable doubt doesn't mean that you're finding the officer is lying. Calling an officer a liar is almost always a bad thing, or almost never a good thing, I would say, unless you have irrefutable proof. And then you give them a way out. Classic case. Years ago, I tried a DWI. The guy was, again, it was refusal, videotape. The officer and the DA did not review the videotape. They didn't put it in on the direct case. Why? I don't know. I think they were just lazy. So I put it in on my cross. The cop was contradicted 20 times, probably 5 for each field sobriety test that he was that he administered. So what do? Instead of, and this is more of a trial practice cross-examination technique, again, don't meet force with force. Don't confront and bludgeon them. Just go with it. Well, officer, sergeant, you just seen this videotape. What you testified to on direct examination is inconsistent with what's on the tape, right? So obviously, we know you're not lying in front of this jury. You're mistaken, right? Now he does a yo-yo. He's just, everything I say, he's just going to agree with. And you've probably made, case was like 2 years old, speedy trial denied, but this was a justice court, never really went. You must have made probably in the last 2 years, 100 DWI arrests, right? Absolutely. And all of this probably starts to mesh together, right? With other cases and cases you had before this, you really can't remember what happened here. But now this tape now refreshes your recollection, and this is the real truth, right? And this person doesn't look intoxicated. He's not falling over. He's doing everything you asked him. So obviously you're mistaken this case with another case. And everything you talked about on direct, where you said my client was intoxicated, you're now telling us he wasn't intoxicated. Judge directed the verdict right there. It didn't even get to the jury. So the point that I'm making is your voir dire has to be specifically tailored to the specifics of each case. And don't do the shotgun approach. Just like in voir dire, you're not going to do the shotgun approach in a trial. Well, something's going to stick, and hopefully one of them will be reasonable doubt. I think nowadays juries expect that if there's going to be a reasonable doubt, you're going to do it based upon a specific theory that you're advancing that's supported by the evidence or lack of evidence, that is, the theory is supported, and then build that into your theme. And everybody knows the difference between a theory and a theme of your case. Does everybody know the difference?
Tell them, John. Tell them what you.
So the theory of your case is why your client is really not guilty. It could be poor police work. It could be just lack of credibility of the witness. The theme is usually a 5 or a 6 phrase, word phrase that's catchy. Best theme ever. If it doesn't fit, you must acquit. And what Johnny Cochran did in his summation, as well as anybody I've seen, is use that glove not fitting into the entire case, putting the police on trial as to why the evidence didn't fit, establishing, proof beyond a reasonable doubt. Now, we all can agree or disagree with the, with that verdict and whether to support it, but it was a masterful job of using that theme to fit in to the theory that O.J. Simpson did not commit the murder, because the evidence was compromised, the evidence was contaminated, and you couldn't trust the police. Nothing fit, including the glove, so you must acquit. So that's the theme of the case. But themes, remember, they start when your client first walks into the office and you start interviewing your client, learning about the case, reviewing discovery. It continues in jury selection, further continues in opening statements, continues through your cross-examination, and then in direct examination if you put on a defense case, and then ultimately bringing it home through summation.
I'm going to,
Sorry, go
before
ahead.
we go into the next question, I'm just going to interrupt you again with the second code. So the second code is duty, D-U-T-Y. The second code is duty, D-U-T-Y. Thank you.
Yeah, another question, John. You're trying to set up a cause for challenge, and you have the judge trying to rehabilitate the witness he's made a lot of statements, or she's made a lot of statements, now not the witness, the potential juror, which raises questions about their being objective. The judge keeps on trying to rehabilitate. What do you do in those circumstances? Do you fight the judge and start asking more questions? You back off? What do you think?
Again, I think you have to know the more specifics of the case. I'm not trying to really opt out of this, but listen, if you know the judge has done an airtight job, you're not going to do that. But you can try to encroach a little bit on what the judge had just did, and I know you just told Judge Brown or Judge Kim, they're just 2 judges in Orange County, how you felt, but I'm just being honest, and because you're going to exercise a preempt on this person, right? So you get a free pass. Being honest with you, Mr. Bongiorno, I'm still troubled. I'm still troubled by your initial reaction. I know we all want to be fair, but the fact of the matter is, we're not vacuums, we don't live in a self-containment. We're influenced by our past experience, things of that nature. And just because this isn't the right case for you doesn't mean that you're a bad juror. You may be a great juror, wonderful person, but maybe a case down the hall dealing with a breach of contract or a motor vehicle accident or a medical malpractice, given your experiences, which again, thank you for sharing, would be a better case. Does that seem right? I mean, but again, you have to, and if they say, no, I'm good, I can still be fair. But remember, whenever you're challenging for cause, to preserve that as appellate review, you had to have used a peremptory challenge on that person and exhausted all your peremptories. Otherwise, if you had a peremptory left over, appellate division is going to say you could have used that peremptory on that prospective juror number 6 and sworn juror number 6, you lose. Does that make sense?
Yes. We're all concerned, a lot of times, we're obviously looking for jurors who are going to favor our case. What about jurors that don't speak in voir dire? How do you've gone through, you're running out of time, and there's 1 or 2 jurors you didn't get to yet, and you have no clue now who these people are, what their backgrounds are. How can you get to them real quick and try to get as much information out in like 30 seconds to try to make a decision?
Mr. Bongiorno, I know you haven't spoken yet. Can you just share with me why, if you're sitting in my client's shoes, why would you be a good juror for this case? Could you share with us that? They're gonna have to answer. I'm fair. I'm open-minded. I came in with an open mind, and I will follow the judge's instructions, and I will not make any decision until it's time to make a decision, and I will follow the judge's rules and listen to what everybody says. Okay. Ideally, that's what you want. If they just say, I don't know, peremptory. Remember though, also during the jury selection and utilization of the peremptory, sometimes the devil you know is better than the devil you don't know. So this really is a chess match, and you really need to know how many challenges you have, right? So if it's round 1 and I know I got to be violent and I have X number of challenges, right? I might be a little bit more liberal and say, I'm not going to ask that person a question. Now, you might be excluding a very favorable juror. I try to make it a practice of asking they like in Rockland County, they like seat 20, they seat 20 in Orange County. They have like 14, then they put some chairs in the front. So they try to get about 20 people, or at least 18, if not 20 per round. So I try to get every single person to speak if it's all possible. And you can always ask for more time. Judge will probably say no, but make the request. What I've been finding lately is some judges, if you exercised all of your peremptory challenges, they offer up another one if you make the request. And most prosecutors' office, I'm finding, will consent to that. They don't want to have retrials.
Yeah, this one, I don't see any other questions, John. I think if you want to wrap it up, we're good at this point.
Okay, so the most important thing, in my opinion, is getting the jury to speak, listening more than you speak, really speaking to kind of say tee up the ball to let them run with it, and just be yourself. Because if you're something that you're not, the jury's going to think about it. Be respectful. Do not interrupt jurors when they're speaking. Whatever you do, never, ever, ever argue with a prospective juror. Because you're never going to win an argument. You're going to alienate that juror, and likely at least probably half of the panel. And then it's really, you've lost what? You lost your credibility, right? Confidence, credibility, entertaining if you can. Nobody has any questions about an upcoming case to brainstorm?
Anyone have any cases they want to discuss? Just put it in the chat. We'll bring it up.
You can even unmute and bring it up. I'm fine
Yeah,
with
yeah, yeah, they can unmute. If anybody wants to unmute and ask a question, go right ahead.
Okay, well, here's my number and my email at the bottom of the PowerPoint. If you guys, guys and ladies have any questions at all, shoot me an email, give me a call. I find that talking about things can be helpful. And again, I don't have all the answers. I can just share with you things that have proven to be effective, but I don't think you win a case in jury selection. I think you can lose a case in jury selection if you don't have the right jury. And getting them to speak, you listening, being authentic and talking about things that bother you, I think is the opening and the paving of the path to an acquittal. I want to thank you, Michael and Barbara, for having me and for everybody else attending. My take on these CLEs, whether you're in person or it's done, virtually, is if you can take away one little tidbit of information, just one, that helps you in a case, it's worth your hour and where are we going now? Hour and 20 minutes that you spent. And I wish you all success. And again, thank you very much for your time and thank you for having me.
Thank you, John.
You're welcome, Mike.
Thank you.
Barbara, you want to pipe in now what they have to do to get their credits and everything and the evaluations?
Well, you should all have received the attendance affirmation and the evaluation form in the same email that you received the Zoom link. So please send that to me, barbara@rocklandbar.org, and then be a little bit patient and I will get you your certificates as soon as possible. Thank you all for attending.
Okay. Thank you, everyone. Have a good day. Thank you, John.
Bye-bye.
You're welcome,
Thanks,
Mike.
Mike.
Thank you.